All right, so welcome to the video series where I'm going over each section of the bankruptcy petition. Today I'm going to focus on two issues when it comes to filing fees. That is actually a common question. How much does it cost to file for bankruptcy? The problem is, and I'll put blog posts there where you can go directly to my website. You have to separate fees from costs. And so what I'm focusing on here is just simply the cost. And so you can pay the filing fee in installments. And then here's the form, official form 103A. You see your applications for individuals to pay the filing fee in installments. It's going to be a quick video because it's just I want to really point out the issues more than what it is to complete the form. The form isn't difficult to complete. But as you can see here, definitely make sure you get the right district. If not, you're going to have issues. And as you can see here, you can ask the court to allow for the filing fee in installments. Now, this is a simple form, as you can see here. It's just basically a one-page form, one page for the judge. Where here you can propose the amounts that you're going to be paying. Here's my problem with this. If you ask for filing fees in installments, and what happens if you go through all the paperwork? What if you're trying to stop wage garnishment, foreclosure, car repossession, and this gets denied for whatever reason? Now you have to scramble to find what's left. I know it's easy to say, to spend other people's money. I prefer, and I think it's the safest route to do this, just to pay it all at once. Currently, I think the filing fees are $335. If you have an emergency, of course, borrow it. You can always pay back your friend, or just don't put that in the bankruptcy petition because they are a creditor. But that's I just think it's risky to try to do the filing fees. I know some lawyers do it. I don't recommend it because the court sometimes takes the approach as well. If you can afford a lawyer, then you can afford the filing fees. And obviously the lawyer is going to be, five times the amount of the filing fees. So it doesn't make any sense in that regard. Now, with that being said, of course, if there is no other option, then by all means do it. My concern is the time frame. Now, there's another form that basically it's the same issue. Let me flip over to that for a second. And it's this one here, to have the filing fees waived. Now, again, if you filed for bankruptcy through a lawyer, I don't think the lawyer should even try this. Doesn't mean I haven't seen it before, and I have. But my concern is, again, if the case is, the judge says, no, your case is going to be dismissed, and the court says you can afford the filing fee, because of course they're probably going to look at what assets you have. And so if it gets dismissed, do you have the opportunity now to come up with the money from one moment to the next? Typically, when you're filing for bankruptcy, you have plenty of time. You know this is going to happen. Even if it's a car repo, you already know, I haven't paid the car in 2 or 3 months. This is about to happen. So just keep that in mind. My concern is always discretion that the courts have, just like I did with the first video regarding the credit counseling courses. It's the same issue. The judge could deny it, and then all of a sudden you need to hurry up and do the credit counseling. So there's time, just take the time to do it. Now, what the court is going to be looking at here, if you are 150% below the federal guidelines. So definitely take that into consideration if you're applying, because you're going to have to put all the information regarding your income, any sort of government assistance, etc. I would even tell you, be careful if there's like a personal injury case involved, if there's a car accident. Likewise, that's going to probably belong to the bankruptcy estate, and these are all things that the court is going to take into consideration. But as you can see here, the form is basically pretty straightforward. It's just asking you questions about expenses and your income as well, to try to determine whether you qualify. To me, this reminds me of a lot of when I was in criminal court, and you see someone asking for a public defender, especially at a bond hearing. You see the judge going through everything, asking, well, how much do you have in savings? You have jewelry. What kind of jewelry? How much is that jewelry worth? Now, while all this is going to be listed, of course, in the bankruptcy petition, well, not always, because sometimes people, file what we call the bare bones petition, and I'll put a blog post on that as well, that I'll put there, which is just basically a petition that's filed in a hurry because time is of the essence. So you are being asked this again. Make sure all this matches, because if it doesn't, you're going to have an issue with the trustee. All right. So those are the two forms to consider, to pay the filing fees in installments or to waive the filing fees if you're 150% below the federal poverty guidelines. And as you can see here, they even go over the issues of if you filed bankruptcy before. And this is not only because you have to wait 8 years to file the second bankruptcy, but likewise, there's always the issue of good faith. Sometimes people continue to file bankruptcy when they're in foreclosure, and at that point, the judge can deny the bankruptcy. We see that happen all the time in court. I've written about that as well. But just keep that all in mind that if you're going to be asking for a waiver, what are the specific situations that you think will grant you to this? Don't just do it as a immediately, instinct. Oh, if I don't have to pay for it, I will. I'm in bankruptcy. I can't afford the filing fees. No, go through the numbers, figure out if you can pay for it. Again, my recommendation, if you can pay in advance, by all means. No, you're not going to be using your credit card to pay for this either. Your credit cards, you should have stopped using them approximately 90 days before you filed for bankruptcy. Okay, so here's the form. This will get filed with the clerk's office, as you see here. The court could deny, just say you'll have to pay in installments anyway. But this is all get submitted to the court. How these orders get submitted to the court, always check the clerk of court's website. Judges have different ways of handling things. These are probably forms that just get transferred automatically to the judge. But I always recommend you review the the judge's particular set of guidelines, because every case is different. For example, some judges might schedule a hearing automatically. Some judges I've seen, when it comes to reaffirmation agreements, schedule hearings automatically, and then there's other judges that don't. So always be aware of the policy. I actually wrote once, I think it was a YouTube video, where I did not appear for a reaffirmation. The judge called me at the office saying, "Why aren't you here?" I was like, "Really? Do we have a judge who does this?" She was a new judge. I didn't follow up on it, and so those are the things that happen if you don't look at the judge's website. All right. Any questions or comments? Feel free to post them in the comment section below, and make sure to look at the different videos that I've already started when it comes to preparing the bankruptcy petition. I've gone over this in parts with my paralegal textbook. The textbook is really made for legal study students and paralegal students, but the videos might help you get more information on bankruptcy and some of the issues that we face in bankruptcy. All right. Take care, everyone, and best of luck with your bankruptcy case.